Huh? Bokatu, Bokatu. Yes. Ah. Hmm. At the request of the learned counsel for the petitioner to withdraw the application, comma, this bail petition is closed on withdrawal. Huh? $34. Perhaps the CD is not available, is it? When do you want it? The learned APP has submitted that the CD is awaited. List the matter again on 25th of March for production of CD. Ah. Ah. She has been informed. The petitioner has been informed in person. When any suggestions? At the request of the learned counsel for the respondent, with the consent of the amicus and the petitioner in person, comma, place this matter on the 26th of March. Yes. Ah. 16. Ah. You are appearing for petitioner. At the request of the learned counsel for the petitioner, list the matter again on 6th of April. Yes. 29. Huh? At the request of the learned counsel for the petitioner, who submits that the compilation is yet not ready. Come on. List this matter again on 9th. 9th of April. Listing. There is a senior bench, sir. Huh? 11. Yes. Huh? Huh? Although the affidavit showing the service of showing the dusty service on the respondent has been filed, comma, none appears for the respondent today. List again on. We'll have it near the Bihu, after the Bihu vacation. 21st of April, allowing the respondent to put in appearance. Yes, sir. Huh? Huh? Hmm. Hmm. You'll find an application for amendment of cost title. Then the matter has to be before us. We'll have to take the file on its turn, sir. Item 8 on its turn. We'll allow it. We will allow it. Let the file be with us. Yes. In this code, you make a mention before the senior bench. Or you have mentioned it before the senior bench. They have sent you here. Okay. Yes. Huh? 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 Item 16 में interim order continues, huh? Yes.
This motion here, item 1.
Hmm.
I'm carrying some getting where they are to taking of valid document.
Yeah.
Next this 14 the money received I purchased it schedule.
Yeah.
And this is for my name is there and the budget number 2 procedure of the 2 purchases
Hmm.
8 numbers of getter and you also to finally see serving persons for task from this square.
Huh?
This square. This square you can now get this result. So this fully money received in all the receipt for my name is there. So it's a local position matter of this vehicle.
Of the cattle. Yes, madam. Hmm. Earlier in few of the ABs, we had allowed them to appear with the receipts. Now he's showing us the receipt. Tell us. Huh?
They have received by of these papers by the
Huh?
they have to receive this paper.
How do you know? How do you know? Huh? Okay. We will call for the CD. In the meantime, we'll give him an interim. He'll produce the receipts. You give us a report whether those receipts are of the cattle or not. Heard Mr. So-and-so learned counsel appearing for the petitioner. Also heard the learned APP. Call for, this is a bill petition with regard to Gauhati PS case number from page 2, huh? From page 2, you'll take Gauhati PS case number so-and-so. Call for the case diary. The petitioner, the counsel for the petitioner has submitted that the petitioner had lawfully purchased the cattle which have been seized by the police, and he is in a position to produce the receipts in case he is allowed the opportunity. Full stop. Accordingly, this court is of the opinion that the petitioner can be allowed an interim bail so that the investigation in the case may proceed in the right direction. Full stop. Accordingly, the petitioner shall be released on bail on furnishing a bond of rupees 20,000 with 2 sureties of the like amount, subject to the satisfaction of the SDJM Gauhati, subject to such conditions as the learned SDJM may find fit to impose upon the petitioner for his participation in the investigation and in the trial later, if so necessary. Full stop. The list the matter again on 21/4/2026. Full stop. Continuance of the bill would be considered on receipt of the updated CD. Yes. Yes, sir. This is an application under section 483 in connection with 483 of the BNSS in connection with from page 1, huh? Sessions case number so and so so and so. Issue notice to the respondent number 2 under the prevalent notification. We'll stop call for the scan copy of the TCR. Huh? Pending before the Special Judge Kamrup Metro Gauhati. List again on. Will it be here on the 27th or later? 24th, on the 24th of March. Ah,
Attempt three.
have I said that? Notice to the respondent number 2 as per. Said. Oh, write the steps within today. Give her a copy.
Attempt three.
Yes. We'll call for the CD in this case. This is a bail application praying under section 483 of the BNSS, praying for bail in connection with from page 1 STFPS case number so and so. Call for the case diary list again on 7th of April. Same order in item number 5.
Attempt four.
Yes. 9.
Just above my small quantity was from the holes of my hydrolysis.
Ah.
But I thought they resisted washing.
Hmm.
But over under the basin of washing.
Basin of
From the kitchen of hydrolysis. From my position. My house is sitting in the area of this house. Now, the police at home lordship, I went there lordship. Looking at police at home, my lord, of Khairul Islam, I went there lordship.
Okay.
Police, yes, lordship.
That day I was telling in the court, there is a saying in Assamese, More uruli punga. One who goes to jumps to see what is happening is also trapped. It is from where? Moirabari. Yes, when the CD.
Ground of arrest, my lord, this is the
Where is the ground of arrest?
17 of
17.
9.2 down, 9.26 down. I just above the small quantity. I comes by the format by the small quantity. Just above crossing 5% lawsuit. From most position it was the cover cost. It was from the house of Khairul Islam, my lord. Such a case lordship. From the specifics, my lord.
9.26 grams. And he is involved in drug trafficking or consumption. 5%. Have it on the 27th. 27th. Call for the case diary 27th. Let it be. Let this CD come. NDPS.
6.
Twice arrested. Not charge sheeted, but you are arrested twice till now. Then? Commercial quantity. Then? Call for the case diary. List again on 10th of April. 10th of April. You have to write that part, huh? This is a application under 483. That part, no, every time. But Mr. S.C. was Learned Counsel paying for the petitioner. At the outset, the Learned Counsel for the petitioner submitted that there is a mistake in describing the opposite party number 2 as the Union of India represented by the Standing Council NCB. Represented by the Standing Council NCB, full stop. The Learned Counsel for the petitioner submitted that it should have been the Union of India represented by Standing Council DRI. So accordingly, he praised that he may be allowed to make a correction to the cause title. to the extent that the Union of India be shown to be represented by the Standing Council, DRI. Any earlier cases by this person? Because we have had a very uncomfortable experience. No, but we had a very bad experience when this was allowed, and later on we came to know that there was another earlier case rejected by another court. Circumvent that entire process. We'll trust you on that. The prayer of Mr. Biswas is allowed. A amended cost title be filed before the registry within a period of 2 days from today. List again after the amended cost title has been filed. No, you have to file the amended cost title. I have allowed you to correct it, but you have to file the amended cost title within 2 days. List the matter again after the amended cost title is filed. Copy of the bail petition to be served upon the Standing Council, DRI. Whoever is the Standing Council. This is a bail petition under section 483, praying for bail in connection with special POCSO case number, page number 1. The learned counsel for the petitioner submitted the charge sheet has already been submitted, full stop. Issue notice to the respondent number 2 in accordance with the prevalent notification. Petitioner to take steps within a period of 2 days from today. Call for a scanned copy of the trial court records. List again on. Victim may turn hostile. Why? Victim will turn hostile. She turned hostile. Where is it? Have you given it? Page number? Yes. We are not deciding anything today, but 30, 35 years you have seen that. She kept quiet. But then she is now implicating her own mother. What to do? DDP and mother. 24th. Today is 17th. 24th, 1 week with 27th. Or you want it on 27th? List again on 27th. It is noticed that the victim has turned hostile during the evidence at the trial stage. We have indicated. Let us see. Yes. Oh, that matter where the lady was asked to lodge a false FIR. Call for the case diary. Issue notice to the respondent number 2 in accordance with the prevalent notification. Stop. This case diary was available in another case, in a BA. You'll find it here. Oh no, AB 411 of 2026. There was a case diary. Story, if I remember correctly, is the girl had gone somewhere. She was having a relationship with the boyfriend. The boyfriend asked her to lodge an FIR against the accused in that AB. Now those boyfriends are on the run. Am I correct? Yes. Huh. Then why are you afraid? How do you come in? Why? Why? What is the connection? You are a friend. Oh, we'll see. We'll see. When can we have it? No, we'll try to have it on the 25th. On the 25th. Huh? We'll have it on 25th. CD must be available. Huh? Take your steps on the, yes, take your steps on the respondent number 2 to within today.
Item 21.
CD is awaited. Hmm. Huh? 11. Page 14. Huh? Hmm. Huh? Huh? So the child is also there now. The relationship is not denied. The relationship cannot be denied. You are denying the relationship. Whose child? DNA test has been done. Then. No. That. You expect a 16-year-old to come and say it on the same day itself. May not be. Can that be a ground for bail? Yes, why is the CD not coming up? Achha, please. What about the DNA report? Huh? But without the DNA report. So the DNA report will be collected by whom? By the IO. And then the IO can send a copy to this court while submitting it to the trial court. Is it not? Huh? DNA report is not there. Had the DNA report been there, definitely we would have called it through the trial court. Or if it had to be submitted directly to the trial court. Here there will be a channel in between. Some other person will get it before the trial court gets it. That person can give us a true copy. Is it not? The DNA report in the matter is awaited. Full stop. The trial court records have been received. Since the petitioner disputes the fatherhood of the child of the minor victim, comma, the learned APP shall procure a copy of the DNA report collected by the IO to be submitted before the trial court and place the same before this court. We only want a copy to see whether the link is there. Ms. So-and-so, learned Amicus, has appeared in the matter and has objected to the bail petition, saying that that the charges are yet to be framed and they may be, and there is an apprehension of influencing the witnesses. List again on, when can we have it? 27th of March.
22.
Yes. CD is awaited.
There was compromise. In close one.
No. Await the scan copy. The scan copy of the trial court records have not been received. Awaiting the same list again on 26th. Registry to issue reminder.
Living day was this, item 25.
Yes, have they been served? Notice served. The learned counsel for the learned APP has submitted that the notice on the respondent number 2 has been served. The scan copy of the TCR is also available. However, there is no representation on behalf of the petitioner. List again on 21st. We'll have to, there is no representation by the respondent on behalf of the respondent number 2. Therefore, this court appoints. Cut diya jayega. We are appointing an amicus. We are appointing an amicus for the respondent number 2. Huh? MK? Yeah, Miss MK Brown. Or Mr. MK Brown. What is the number 2?
I don't see it. Getting that.
Miss MK Brown as the amicus to defend the interests of the victim and the informant. Full stop. List again on 23rd of March 2026. Petition, counsel for petitioner to serve a copy of the bail petition on the learned amicus within tomorrow. Give the name. What is, give your name. Give it to her in writing. Yes. Huh? How can there be a compromise? No, it's not about compoundable. Once they say that we are not afraid if the man is left out on bail, we are considering the bail, not the merit of the matter. If he is found to be guilty, he goes. There is no problem. Convict him. No problem. But when the apprehension of anything goes and there is a statement made that it was filed out of misunderstanding, should he await the full trial? Hmm? Where is that FIR? Huh? Page 7. And where is that crime report? Hmm? Crime report, where is it? You have mentioned some crime report, medical report. 20. Yes. In these circumstances, will allow the bill. They have filed an affidavit even in their absence. Have you seen the affidavit? No. You please see the affidavit. Have a look at the medical report and have a look at the affidavit. We'll take it up after some time. Medical report does not suggest anything. And the affidavit says that it was due to pressure that we had done it. Intelligence of the child per the medical report is low. So she could have been manipulated. We'll allow the bill. We can be. He'll appear before the trial court for what? Not charge sheeted. Not charge sheeted. It's an AB. That might be have been a. There is a charge sheet. It's charge sheeted case. You were not arrested during this thing, no? Heard Mr. A. Shamal and counsel appearing for the petitioner also heard the learned APP. This was an application under section 482 BNSS praying for grant of pre-arrest bail in connection with Roha PS case number 59 of 2024 under section 64 of the BNS read with section 6 of the POCSO Act, which had culminated in. Yes. What is the case number? Mr. Sharma, you should be prepared with this. We won't do the searching for you. You are giving us the PS case number. Fantastic. Which has culminated in special POCSO case number 224 of 2025, pending in the court of special judge within bracket POCSO Nagaon, Assam. Full stop. The learned counsel for the petitioner has submitted that the petitioner was not taken into custody during the period of investigation. And now after the charge sheet, the petitioner was apprehensive that on his appearance before the learned trial court, he may be taken into custody and therefore the anticipatory bail petition had been preferred. The respondent number 2, oblique informant, has appeared before this court by filing an affidavit according to which the informant has submitted that the petitioner is their relative and out of misunderstanding and public pressure, the FIR had been lodged and now they have come to a settlement amongst themselves. Full stop. The medical report annexed with the charge sheet does not reveal signs or evidence of recent sexual intercourse or any sign or evidence of recent injuries on the body or private parts of the alleged victim, although the medical examination was done on the same day. Although the medical examination was done promptly, full stop. Accordingly, this court is of the opinion that the petitioner would approach the learned trial court to pray for regular bail along with the certified copy of the affidavit filed by the informant before this court. How do you presume that? And has the charges been framed? So once you appear, pray for a regular bail with the observations made by this court, and pray for not only bail, what do you call that? Discharge, because of the compromise and the fact that an affidavit has been filed before this court that the FIR was on a misunderstanding. Hmm? Hmm. Okay, you cut out the last sentence. In view of the above, this court is of the opinion that can we grant it like that? Can we grant it like that? Whether he'll face trial or not, how do we know?
So during the trial, the victim and the informant is said, the case has been closed.
You take it like this.
The trial court will take
In the in the facts and circumstances, this court is of the opinion that the petitioner should the petitioner is it a charge sheeted case? Case diary shall be returned. We are on a case where it has been charge sheeted. Should we interfere? Should appear before the learned trial court to make his submissions if required for discharge on the basis of the statements made before this court on affidavit by the informant herself and on the basis of the report of the medical examination of the victim, full stop. The petitioner shall appear before the learned trial court on or before the 31st of March 2026, full stop. In the meantime, if the petitioner is taken into custody, he shall be released on bail on furnishing a bond of rupees 35,000 with 30,000 with two sureties of the like amount before the learned trial court. Anticipatory bail petition stands disposed of. You go and appear before 31st, get your orders. Till 31st, you are not being arrested.
24.
Yes.
Item 24.
That is the whole thing. Have you appeared? Huh? Find out whether you have appeared before the IO or not. Yes.
Wow, that's
Alhamdulillah.
item 25.
What is the matter about? What is the matter about? Criminal appeal. Service of notice on respondent number 2 is awaited or what? Huh? Service of notice on respondent number 2, Mr. APP. All those steps had been taken upon the respondent number 2 on August 20 on 20th of August 2025. The service report is yet awaited, full stop. In the facts and circumstances, this court deems it fit to appoint an amicus to defend the interest of the informant and the victim. Yes, accordingly, by interest like Bhattacharya করে নাকি D Bhattacharya? D Bhattacharya স্যার কোন আছে? A Fukan. A Fukan criminal, huh? Mr. A Fukan learned counsel as the amicus in the matter. Full stop. The counsel for the appellant shall serve a copy of the appeal upon the learned amicus appointed today. Full stop. List again on 31st of March, since the trial court records have also been received. Yes. 31st of March. We have appointed an amicus. You serve a copy on the amicus. Yes.
26.
Service report on the respondent on the informant has been received. However, none appears today. We'll wait for it. We'll wait for a week for appearance. They have been served. We'll wait for a week for her appearance. If none appears, we'll take it up on the next week for an appointed amicus. List again on the 26th of March, awaiting the appearance on behalf of the informant.
Supplementary item 26.
Why? Why should he be under the Hojai PS? He should be under the court, jurisdictional court. Huh? That is the whole problem. The person is from beyond the jurisdiction of the trial court, is it not? So someone from within the jurisdiction has to give the bail, has to stand bailer. So what was he doing there? Why did he go to make his sale there? Sale of what? Local surety. Yes, what do you say, Mr. PP? To reduce. Huh? Huh? He wants the bail amount reduced and the surety to be within Assam. That may be done. What about the bail amount?
1 lakh.
Okay. 1 lakh. You have landed property. Any landed property is beyond 1 lakh. Then, no, the cousin who's giving the bill, any landed property is more than 1 lakh. Why do you worry? Huh? We'll bring it to 1 lakh and yes, Mr. PP, the bargain is between you and the counsel for the petitioner. Huh? Hmm. The learned counsel for the petitioner in this interlocutory application has submitted that though the petitioner had submitted the details of a bailer along with the bail, the same had been rejected since the directions of this court require the bailer to be to have to that at least one of the bailers should have landed immovable property in his name within the jurisdiction of the learned jurisdictional court. The learned counsel for the petitioner has also submitted that the bail amount being on the higher side, this court may also consider reduction of the bail amount, full stop. Accordingly, the learned PP has also been heard, who has submitted that reasonable conditions may be imposed in the event this court reduces the bond amount and gives a relaxation regarding the necessity of the immovable property being situated within the jurisdiction of the learned trial court. The submissions have been considered. In the facts and circumstances, this court directs that the condition regarding the bail bond of rupees 1,50,000 shall now stand reduced to 75,000 with two sureties of the like amount, one of whom shall have two sureties of the like amount, at least one of whom shall be a resident within the territorial jurisdiction of the trial court, and at least one of whom shall have landed immovable property in his name within the state of Assam. One local and one with a landed property. Okay, then strike out that portion. Resident of the territorial jurisdiction, or at least one of whom shall be a resident of the jurisdiction of the trial court. Call he part to the other conditions given in the bill in the order dated 23/2/2026 in connection with bail application number 273 of 2026 shall remain the same. We'll make the correction. We'll have two sureties within the state of Assam, one having a landed property, 75,000. Huh? Same person. Oh, that is why perhaps we had given this. He was involved in two cases. I disposed of. দুইটা কেছতে একে হ'ব হা খালি বিল পেটিশন নাম্বাৰটো বেলেগ হ'ব দুটা কেছ আছিলে অৰ্ডাৰ আইটেম নম্বৰ Non-appeals লিখিছো নেকি? Item 35 আপুনি লৈছিলে নেকি? কৈ দিব। You give your name in writing and you give your name in writing and the item number. এটা ফোন কৰি কৈ দিয়ক তেখেতক পিএছক। Non-appeals টো কাটি পেলাই আৰু নামটো দি দিব।
For admission, item 12.
Hmm. No, you have to tell us about that order dated 24/2/2026. Learned counsel for the petitioner prays for some time to go through the law point as to when there is a bar for second revision before the High Court, whether the petition can take recourse to Section 528 of the BNS for invoking inherent powers of the High Court. Hmm? Hmm. Hmm. That is the question. Whether the petitioner can take recourse to Section 528 when a second revision is barred. Name and hmm? Yeah, what is your ground? What mechanical? Which is the order? The 20% deposit. 20% deposit. Yes, it to do away with the 20% deposit, you have to give reasons. 20% deposit is routine. You don't need any reason for that. Huh? Show us. Show us. Show us. What is that name? No, reduction cannot be mechanical. Huh? Para 15. Para 15. Oof. Huh? Very good. Okay. Please read again. It was further observed that when the appellate court decides not to direct, when not to direct, then it is you are aggrieved by the direction to deposit 20%. We have already dismissed similar matters. No, you have to the 20% has to be there if
There are 19. The exercise of power under section 3 is that this discretionary, the provision is that can only reward method. While deciding the fair match under the court must record brief results indicating consideration of all relevant factors. That's it. In my case, there is nothing, only section is recorded. If there is a single reason that administrator there is nothing to say that you are. Therefore, this situation will remain better. I am not asking for dismissing it. The may remain back by this time. They also remain back. Consider it. Is now that I am taking the loan from Gimlers. I am taking the loan from father who has a business relation who has died. After that, if they have come with a power of attorney that now you have taken a loan. So they say amount was within the for business purpose for security. If I have society, sir, there is some establishment that was cannot.
NI conjunction. NI conjunction.
Person. That there is a good relationship.
Case number?
Here is the there is the provision to recover the amount of complaint. Paragraph 4. Paragraph 4. It is indicative. There was something said. It is very regarding to recover complaint.
What do you say about this? Paragraph 19 of this judgment. Have you gone through this judgment? Have you gone through this judgment? Hmm?
It might not be submitted original
143A.
is not
Huh? No, we are not on that. Legal sentence.
the petition filing under section 143. Is not
Not annexed. You need not.
that is how
Can you say that you have deposited?
without revealing the petition.
I can bring your suggestion. Law is
It is better if the court has half the documents before it while deciding a matter, is it not? Hmm?
mechanically right or not. He has given you the board before. Trial court and appellate court. So this is not appellate court. What you will decide is what I want to make. Some part of the law. If one line has been written, I have nothing to say. That
How can we find you without
it does not.
without revealing the
It does not. Nothing has
this
been
is the
written.
judgment, but we have not seen that it's not file on the same.
It is not held by team.
He was selling for that on the books of
No, that case that we had seen was for during the appeal. This is during the trial itself. In your case, it is during the trial itself. It has to go back. Yes, it has to go back. Have you seen this judgment? Rakesh Ranjan Srivastava. Have you seen this judgment? You have not seen. Go through it. We'll take it up at 2. Go through Rakesh Ranjan. The Supreme Court has held that while deciding a petition on 143A, interim compensation, there has to be a reason. Where is the reason? The order has to show. The order has to show that there was a reason given. In the petition, there are reasons. Hey, why did you not bring it? Why did you not bring it today? He has not furnished. You have not furnished. And this court is supposed to keep a litigation hanging because you are not bringing documents. And whatever he deposits, in case he's found to be innocent, you have to give him back. At the request of the learned counsel, paying for the respondent. List this matter again on. Take a date. 27th of March 2026. Mr. Mohanto, learned counsel paying for the petitioner, has submitted that in view of the law laid down in Rakesh Ranjan Srivastava versus State of Jharkhand and others, Criminal Appeal number 741 of 2024, decided by the Apex Court on 15/3/2024, any order requiring payment of compensation under section 143A(1) of the NI Act is required to be done only after due application of mind to the quantum of interim compensation to be granted. Full stop. He has submitted that in view of the aforesaid judgment, the matter requires to be remanded back to the learned trial court to decide on the quantum of the necessity, if any, and the quantum of compensation, if any, required to be deposited by the accused oblique petitioner hearing on the basis of reasons to be recorded in the order.
Item 24.
That is all right, but the higher secondary exams are over. Now, have you gone and appeared before the IO? Your statement has been recorded. And what about the service of report, madam? Huh? Kindly have the instruction on the service of report. Huh? Or since you are an interim, will the case diary is awaited. Service report on the service of notice on the respondent number 2 is also awaited. The petitioner is on interim bail. List the matter again on. Yes, tell us a date. 8th of April 2026. 7th of April 2026, allowing the learned APP to procure the case diary as well, updated case diary as well as report of service of notice on the respondent number 2. The interim order passed earlier continues.
Item 14.
Yes. Has been paid. Why? What is no, the total amount was 8 lakhs. 20% would come to 1.6 lakhs, not paid. Hmm. Hmm. Where is execution petition? No, he was allowed to remain on bail. Where is the execution? Huh? Where is it stayed? Where is, you going in from the executing court? Trial court records have been brought here. Huh? So what do you want to do? That is when 143A1. But no. Deswal again says that in an appeal for reduction you have to give a cause, not for 20%. No. In that this was given in trial. Oh, you have come against an order by the appellate court. Is it not? In the earlier case, during trial, that compensation was required to be paid. So now there is a difference. In the appeal, you already have an order against you. Therefore, the appellate court requiring you to pay that 20% does not need any further reasons. You are a convict. Is it not? But if it is to be done during the trial under 143A1, then the trial court has to give reasons why it is asking you to deposit a compensation even before you have been held guilty. So that Rakesh Ranjan is gone. You are here against the appellate order. Is it not? So appellate order does not require to give reasons. This High Court told you to go and deposit it. You have not deposited it. Calling for this trial court record here in original has frustrated the whole process of a negotiable instruments act case. He is not paying the amount and the records are here. He is not being able to proceed. So what we will do today is we'll ask the TCR to be sent back after retaining a scan copy. Once the TCR goes back, he would move a appropriate application. Will give the liberty to him to move an appropriate application for execution. Is it not? What do you say? We will dismiss this. We will dismiss this revision because he has not cooperated. Then he will come back. Then he will make a hue and cry that it should be restored, or he will go and get an order that it should be restored. Again, everything will come back. Will you benefit? Will you benefit? Or should we dispose it of on merit? What is your huh? We are hearing it. You are not cooperating there, you are not cooperating here. How? Your client is not cooperating and you are also not cooperating. We'll simply do one thing. We'll send back the trial court records by retaining a scan copy. Scan copy to retain korabo paro to registry. Scan copy to retain korai dim. Trial court record to পঠিয়াই দিলো তেওঁ তাতে নিজৰ হেৰি কৰি থাকিব heard Mr. So and so and a counsel appearing for the petitioner also heard Mr. So you are Mr. PK Das and you are DP Goswami huh G.J. Sharma. Okay. Heard Mr. P.K. Das, learned counsel for the petition. Also heard Mr. J.J. Sharma, learned counsel appearing for the respondent. Number 2. Ms. So-and-so appears as the learned APP for the state of Assam, full stop. By the order dated 10/11/2025, the petitioner was required to deposit the 20% of the amount which he was directed to pay as compensation before the trial court within 6 months from the date of from the 6 weeks from the date of the order. Full stop. In the event that the petitioner deposited the aforesaid amount, comma, it was directed that the operation of the impugned judgment would remain in abeyance during the pendency of the criminal revision petition. Full stop. The petitioner was also allowed to remain on bail of rupees 50,000 with one surety of the like amount, subject to the payment of the 20% of the compensation amount as directed in the order dated 10/11/2025. Full stop. Today, the trial court, the records of the trial court as well as the first appellate court were also called for. Full stop. Today, a submission has been made that the petitioner has not fulfilled the directions of this court for deposit of the 20% of the amount of which he was directed to pay as compensation before the trial court. Full stop. The learned counsel appearing for the respondent number 2 has submitted that since the trial court records and the appellate court records are and have been called by this court and are available before this court, comma, the respondent number 2 has not been able to initiate steps for execution of the order passed by the learned trial court. Full stop. This court has considered the circumstances of the case and is of the opinion that that to facilitate the since the petitioner has not complied with the orders passed by this court, comma, he cannot be allowed to further. He need not be allowed to further enjoy a stay of the orders passed by the learned trial court and or the privilege of bail granted by this court, which was on the condition that the petitioner would make a deposit of 20% of the compensation awarded by the learned trial court. Full stop. In such circumstances, it is directed that the registry would retain a scanned copy of the records of the trial court and the appellate court and forthwith arrange for the return of the records of the trial court and the appellate court so that the respondent number 2 would be in a position to reinitiate the proceedings for execution of the orders passed by the learned trial court. Full stop. List this matter again on, we'll have it in April sometime, on 27th of April. You initiated there. You build your pressure. Why not? Huh? Who will deposit? He has not deposited. You go for an execution. Okay, on the 20th of April. 20th of April. More early. 22nd of April 2026 in the hearing column. Kuntu. Sorry, more order to say supply.
Item 15.
Oh, yes. I have sentence up. It is made clear that the time frame given by the order dated 10/11/2025 has not been extended by this court. Even if he now deposits anything, it doesn't work to his favor. Okay. Yes. Huh? Huh?
Penalty is case number 11.
11. Huh? Hmm.
That's it. But he has complained to get a user to get a value in the morning, and he has to do all perform all the household work. That is to bathroom and wash all the room, all the utensils, wash clothes of the OP, cook food for breakfast, lunch, evening tea, and snacks. These are the matter mental process matter.
Hmm.
Nowadays, matter every kind of household woman does this work.
Not nowadays. Earlier they used to do. Nowadays is a question. And why the ladies only? Gents are helping. You need a helping hand in the house. Ah. Hmm. Hmm. Oh.
That's not I have order
21?
What?
21/1/2026.
I have disclosed my earning minus as 8,000. In other trial was given maintenance of 7,000. Only 1,000 less to me.
Hmm.
If I ask me was Neha minus, I have disclosed my salary minus as minus 8,000. That I am in section of a procedure.
Hmm.
That is detected in the order. 1,000 minus high. Okay, 17 months.
When will you be available? You are filing your objections today. They are filing the objections today. We'll have it on the next week. Huh? Tuesday. 24th, huh? List the matter again on 24th of March. On since the Learned Council appearing for the respondent has submitted that they will be filing the objections today. Hmm? Is being filed today, full stop. The interim prayer would be considered on the next date fixed.
17.
Yes. Mm-hmm. LCR has been called for and received. Yes, proceed. Huh? Hmm. এইটো কিহত আহিছে? Huh? Hmm. Page 20. Hmm. Hmm. Huh. Yes, you were found in a flat and all that. That was the matter. Hmm. Then what happened? Uh, uh,
Nothing has been found. Second. That's new offense. New kind of here.
hmm.
There were only informant met some statements in their 161 statement also that he is involved. He is not involved in the alleged offense. Except that matter, how he is involved. What implementing utensils here, nothing has been recognized.
Yes, sir. Which is the order? Huh? LCI is there. Last time you took some time to to go through it. So one of the person has to appear and go through it because we forget who short time. Huh? Yes. 24th. 24th. We'll record your name that you would go through the today he will go through. But on the next date you have to be there. Mr. KK Parashar and a council paying for the Lanet APP has sought for an accommodation today. Full stop. List the matter again on 24th for consideration on 24th, allowing Mr. KK Parashar to go through the trial court records. Full stop. Cause list to reflect the name of Mr. KK Parashar. We are asking the registry to reflect your name. Item 18 will take it up after 10 minutes. We'll try to finish a little more clear this matters. And then we'll try to take it up. Kita sir, by that.
Item 19.
Yes. PCR আহিলে নেকি? PCR আহিছে নেকি? হা? The trial court records received appear to be incomplete since the affidavits of assets and liabilities are not included. Full stop. Register to call for the complete records of the TCR. Register to call for the scan copy of the complete TCR records, including the affidavits of assets and liabilities filed by the parties. List again on 30th. Huh.
There's no stay order in the matter.
It is made
He's
clear.
not paying anything till.
It is made clear that there is no stay order operating in the case, huh? When you did not get a order on the first date, would she be
It was heard in
the
detail.
wife? Wait, what is the order dated? What is the order dated?
Was the on 20th of February 2026. Notice was issued in this matter, Your Lordship.
No. The order which has been challenged.
Impugned order is
5/1/2026. Huh?
5/1/2026.
The impugned order is 106, Lordship.
Hmm.
Here, the court has decided the interim maintenance. The relief we have sought for is that the interim maintenance should not be from the date of filing of this matter, it should be from the date of order.
Okay, now, why are you not filing, why are you not depositing the amount from the date of the order?
We are ready to give
You have not deposited it.
because
The petitioner, the counsel for the petitioner has submitted that the
the matter when placed.
just a minute. Your grievance is that it should not be from the date of filing, but from the date of the order, is it not? The learned counsel for the petitioner has submitted that.
But that is a settled law, Your Lordship.
No.
In any case,
For the time being,
Time.
we'll direct him to
Time.
deposit it
yes,
from the date of the order,
correct.
so that you are not put to
Prejudiced.
harassment.
Especially
And
my child, Your Lordship. Yes.
and when the TCR comes in, we'll have a hearing whether it is from the date of filing.
That when we go to Article 125(2) of the CRPT.
Sir, do you have any objection in paying the amount from the date of the order now? Just tell us that. So,
We are ready.
Learned counsel for the petitioner submitted a reason under instructions that the grievance in this petition is regarding the direction to pay the maintenance from the date of filing of the petition. However, the petitioner is not uh, averse to paying the amount from the date of the order. Accordingly, the petitioner would deposit the maintenance granted by the trial court
For the last 3
at
months
regular basis, including the arrears
from
for the
January.
month of January and February within a period of 15 days from today. The কাগজটো লিখিছে trial court record to call কৰিবলৈ. We have asked you to deposit it for February, January and February and March regularly. The earlier part will decide once the matter is taken up.
Lordship is fixing a date,
Yes. নিদিলো নেকি date?
after Bihu, or before that, as per your Lordship's convenience.
22nd of April?
Yes, your Lordship.
22nd.
Look,
No? Peace of land.
27th of April. Yes.
Deeply obliged.
নামবোৰ record কৰিব দেই, মই নামবোৰ কোনে নামবোৰ চব record কৰিম। I'll just be back in 2 minutes.
There have been one matter, item 17.
Hmm.
Just I have take time to go through. In earlier occasion, 21/1/26, I have prayed that Malat, all records are not there. Malat, LCR is there, but the CD part is not there. Same condition is today also, Malat. Malat, there is the earlier order 21/1/26, next order. That entire record was called for, only that trial court record is there, but we have to go through the CD. That CD part is not there, LCR.
CD part is not. সেইটো order আপুনি লৈছিলে নেকি? When did we fix it? On 24th.
It will come raised.
You call the petitioner if you need to change the order.
I'll call.
Because we'll have to grant some more time then.
Other than the CD part, it will come through registry. Now, that case.
It will come through registry, but it will not reach before 24th. Will it?
It will come, through email it will come.
তেতিয়াহ'লে সেইটোত আকৌ এড কৰি দিয়কচোন। এইটো অৰ্ডাৰতে এড কৰি থওক। On 21/1/2026, the learned APP had submitted that the trial court records contain only the orders passed in the case, the charge sheet and the FIR. Full stop. The registry was required to call for the scanned copy of the complete case record from the trial court, including the CD. Full stop. There is oh, 6/2/2026.
And it was may not be looked into, but I have now perused, CD part is not there.
The trial court records have been again received by the memo number 164 dated 6/2/2026. The learned APP has submitted that it still does not contain
The case diary part.
the case diary part. Full stop. Registry to issue reminder to the learned trial court to send the scanned copy of the case diary also before the next date fixed. We'll keep it on the same date. Yuck.
This will be
It is.
20.
Yes.
Yes, Lordship, we have received the JIMMA report, whereby Lordship, the concerned IO is objecting the JIMMA of the seized truck on several grounds, Lordship. First
Yes, this truck was used.
One judgment that driver and handyman was not arrested in the case also. They are released without arrest.
Why?
And the
Another request, lordship, the meaning of the said.
They were released, driver and handyman,
Please, not read.
not arrested.
The lordship, the judgment, non-judgment lordship, the my
Which
name
one?
is not there in the,
In the what?
yes, in the case.
So
So the.
you are using you are allowing the use of your truck.
Supreme Court judgment Vishwajit
Huh.
versus the state of Assam.
Huh. Four conditions given.
If the, my name is not there, I am.
Four
not a-
conditions given.
I am not a accused in this case, Lord. Then the my.
Charge sheet is submitted.
No, Lord.
Then how can you say you are not a, if the charge sheet has not been submitted, your name may still come up when the charge sheet is being submitted.
My vehicle is a commercial vehicle. Lord.
Huh.
Lordship on judgment is there, Lordship.
If it is a commercial vehicle, then there will be no, it can be released.
Other way also,
All
Lordship,
the trucks will be released. All trucks are commercial. Show me one private truck.
Still
Eh?
there, finance. Another
Show me
request,
one, show me one private truck.
The lordship, my vehicle was held by one minor. Is the accused in this case, Lord. He is released in September.
What does it say?
In this judgment, Lordship.
Ah.
Yes, sir.
Hmm. In the case before the Supreme Court, there was a charge sheet. There is still a scope that the police may find that you are allowing your vehicle to be used and you may become one of the accused.
I am
So
not
will that,
in this,
no, in the FIR you are not there.
on the lordship agreement, the minor person is had my vehicle
Hmm?
for monthly basis rent. He is the main accused, Lordship, in this case.
Lordship, ownership of the truck is yet to be asserted because.
Ownership.
Yes, Lord.
Ownership, he will give the requisite documents before the,
He's not yet appeared before the IO
Petition
with the valid
this is
document.
not a bail petition.
It's a
Have
Jibba
you
petition-
appeared?
Jibba petition regarding,
submitted
he
the,
has claimed the ownership of the truck, Lordship,
Who?
the present petitioner.
Huh?
But that,
I've told
that he
you
has not
that-
appeared before the PS, concerned PS date with the valid documents, Lordship. On the top of that, for further investigation and for collecting evidence, Lordship, this truck is required because.
So once we allow you the supervisory, the next AB comes up. That to go and get the vehicle, allow me the bail
the,
so that I can go and get the vehicle.
the import order page 22, Lordship,
Hmm.
last paragraph. The prior to giving of Zimmer of the said vehicle, other.
Any modification made to the vehicle?
Yes, Lordship.
Modification was made, what?
Because there's a secret chamber has been found
Oh,
inside the vehicle, Lordship. And there is every possibility of transporting
secret chamber.
smuggle.
Driver and independence release, police, Lordship. They are not arrested in this case, Lordship. Why not arrested, Lord? I am the owner. And my vehicle was held one minor on monthly basis, Lordship.
When was the vehicle taken? Confiscated?
Lordship.
On?
It was at the impugn order, your Lordship will get it page 21,
12, Lordship.
No.
18 to 20.
When was it taken into custody?
16, 12,
On 15/12.
25.
on 15/12.
15/12.
From the driver and handyman. Driver and handyman, not a issue.
Lordship will get a clear picture if a lordship kindly come to page 21. The impugn order dated 18/2/2000.
We have seen the only reason for rejecting the Zimma is because
Because
of the ownership.
ownership, he has
He'll,
not
he'll
appeared.
go and give the
And
ownership
also
detail.
found a secret chamber inside the vehicle, lordship.
That is not the ground for rejection.
Lordship, kindly go through the reports.
Yes,
Only
I
the-
deem it
That is
proper.
submitted on 16/03.
However, considering the fact that ownership of the vehicle could not be ascertained yet, call for the this thing.
The
DTO report.
DTO also failed to provide a valid report, lordship.
He'll get a report.
Lordship.
He'll apply for a report and he'll produce it.
Lordship.
With documents.
And then if you become an accused, you'll go after you come back to this court, huh? Hmm. What was recovered?
Lordship, betel nut.
For a betel nut, why
Lordship,
do you
that is
need secret
Burmese-
chamber?
Burmese supari.
No,
lordship.
for betel nut, why secret chamber is required?
Because it is coming from Burma. So
Ah.
it is suspected to be illegally transporting, evading tax and revenue. lordship.
Done, madam. A truck is carrying betel nut.
Yes.
What-
This
Where is the issue of a secret chamber?
2,571
If you are talking of,
cases of
if you are talking of
Burmese supari,
cough syrups, talking of small tablets,
lordship,
talking of gold,
lordship,
heroin,
lordship.
secret chambers. The entire truck is carrying betel nut.
Lordship.
This is just harassment.
Let him appear before the IO lordship with the
Ah.
valid documents, lordship.
Heard the learned counsel appearing for the petition. Heard Mr. So-and-so learned counsel appearing for the petition. I also heard the learned APP. The police report called for from the IO regarding the vehicle in issue has been received. As per the report, the truck bearing registration number A01NC2736 was clandestinely transporting illegal Burmese areca nut by constructing secret compartments and without any valid permission from the transport department. Please stop. The grounds for objection to the Zimma petition have been enumerated from where it reflects that suspected illegal smuggled areca nuts have been recovered and that the owner was not yet verified. Full stop. We have also, this court has also been taken to the order dated 18/2/2026, where the learned trial court has rejected the prayer for custody of the seized truck only on the ground that the ownership of the truck could not be ascertained till then. Full stop. The learned counsel for the petitioner has submitted that given an opportunity, he would be able to prove the ownership of the truck, and thereafter, if the said vehicle is released to him in custody, appropriate care would be taken for production of the vehicle for investigation and also during the trial, if any, and also would be made readily available for confiscation if so required by the orders of the trial court. Full stop. The learned APP has submitted that the ownership of the truck being in doubt, and since it was used for transporting illegal Burmese areca nut, the prayer for custody may be rejected. Full stop. We have this court has considered the submissions made, a full stop. Since the ownership of the truck is the only hinge in allowing in the trial court allowing the custody of the vehicle, it is provided that the petitioner shall appear before the investigating officer on or before. Tell us.
Yes.
Today is 17, 22, 32. On or before the 6th of April, 2026, along with all relevant documents to prove the ownership of the vehicle. And in the event the petitioner is found to be the owner of the vehicle, the vehicle shall be released to the petitioner. Can he release it? No. Can he release it?
Lordship,
Will he release it or the trial court?
trial court, Lordship.
The trial court has to release it. So he'll have to appear before the trial court, not the IO.
Yes.
Appear before the investigating officer, who shall on proper verification of the credentials submitted by the petitioner and upon finding the petitioner to be the owner of the vehicle, shall release the vehicle to the petitioner on the petitioner furnishing a bond of rupees 50,000 for production of the vehicle as and when required by for the investigation or the trial, if any. Stop. Criminal petition disposed of.
CD is there, Lordship, that may be sent back.
The case diary call for may be sent back by the APP.
And the report that may be kept as a part of the record.
The report is kept as a part of the record. The report dated 16/3/2026 is kept as part of record.
Nice, Lordship.
Look. এইকেইটা কি হিয়াৰিঙত আছে নেকি? এইখন দিয়ক, ইয়াৰ লগত আৰু এটা ফাইল আছে নে? বগা ফাইল এটা আছে নেকি? Our last order dated 10/2/2026. Because of one comma, the entire order has changed, and I did not notice it. It reads, the matter was listed today before this court on the issue whether a writ petition is maintainable in the given facts and circumstances of the case. Full stop. So now that came down. Whether a writ petition is maintainable in the given facts and circumstances, extensive arguments have been made. And I did not notice it. Yes, heard Miss Ujjani Chatterjee, learned counsel for the petitioner, and also heard Ms. R.S. Chaudhary, learned counsel, appearing for the Assam Royal Global University. The extensive arguments had been heard on the maintainability of this writ petition on 10/2/2026. Stop. With the consent of the parties, the initial issue is taken up before the merits of the grievance raised by the petitioner are addressed by the court. Stop. The assertions made in the writ petition and the documents annexed thereto reflect that the petitioner had been appointed as an associate professor in the Royal School of Law and Administration in the Assam Royal Global University by an appointment letter dated 22/8/2022, issued by the registrar of the university. The terms and conditions of the the salary of the petitioner was thereafter revised by an order dated 28/11/2022, and her remuneration was further revised by another order dated 4/10/2024, each of the orders being issued by the registrar of the university. During her service tenure, the petitioner had been recognized approved as a PhD guide of the Assam Royal Global University. As per the terms of section 15 and 16 of the Royal Global University Ordinance -4, the tenure of the guideship would be valid till the petitioner remained associated as a regular faculty of the Assam Royal Global University. While the petitioner was performing her duties as a guide to different research scholars, some of them part-time research scholars, one of the scholars had made a request to the chairperson of the, what is the DRC full form? Of the DRC to tapni eta heri mai thabo eta longa kori dibo. Of the DRC of the university.
It's Departmental Research Committee. Departmental Research Committee.
Departmental Research Committee, huh? In bracket,
Yes.
DRC. Asking for a change of guide. The issue was therefore taken up by the DRC and certain observations were made in the meeting held on 27th of June 2025. On the 10th of October 2025, the petitioner was called to the office of the registrar within bracket administration, where she was informed that having failed to meet the expectations of the competent authority, there was a suggestion that she disassociate from the university. Aggrieved by such a suggestion, the petitioner had submitted a request for appointment to the office of the Vice Chancellor of the university through email, through her personal email, since her official email had been blocked by the administration. The reason for seeking the appointment by the petitioner as reflected in the email was that a sudden discontinuance of her services with the university may hamper the research and final submission of thesis by the two PhD scholars whom the petitioner was acting as a guide. Full stop. By another communication made through email on October 22, 2025, the petitioner requested the Chancellor of the University not to deprive her of the opportunity to complete the guidance to the two research scholars who were at their final stage of submitting their thesis. Full stop. By the aforesaid communication, the petitioner had submitted that although she had lost her job in the university, allowing her to successfully complete the guidance to the two PhD scholars would help her find another job and also help her in her future career. Full stop. The writ petition has also referred to an email made by one of the PhD scholars to the head of the department, law of the university to allow the petitioner to continue to be her supervisor till the completion of her PhD. Full stop. It is the case projected in the writ petition that by another email dated October 25th, 2025, the petitioner had again made a request to the chairperson of the DRC, RSLA of the university to allow her to work in absentia if required to complete the task of to guide the two PhD scholars for submission and pre-submission respectively at the earliest. Full stop. Thereafter, as per the assertions made in the writ petition, the impugned order dated 25/10/2025 came to be issued by the Registrar Administration and Director IQAC of the university, wherein it was informed to the petitioner that her employment as associate professor in the RSLA, Assam Royal Global University stood terminated with effect from 17th of October 2025. Full stop. Certain allegations of non-adherence to the expectation of the university, defiance and argumentative conduct, etc., had been leveled upon the petitioner by the letter dated 25/10/2025, By the aforesaid letter, the petitioner was requested to complete all exit formalities at the earliest and to return any university property in her possession. Full stop. Notice in this case was issued on 15/11/2025. Stop. On the university putting in their appearance, comma, an affidavit in opposition had been filed through the registrar of the university. Full stop. The said affidavit was stated to be confined strictly to the preliminary objections being raised on behalf of the university to the extent of the maintainability of the writ petition in its present form. The petitioner filed an affidavit in reply, and therefore the matter today is taken up to adjudicate as to whether the writ petition in the present form is maintainable. Full stop. Ms. U. Chatterjee, learned counsel for the petitioner, during the course of her arguments, had submitted that that it is an undisputed fact that the university had been brought into existence by the Assam Royal Global University Act, 2013, read with Section 6 of the Assam Private Universities Act 2007. The university exercises academic, administrative, and supervisory control over the Royal School of Law and Administration, where the petitioner was employed as an associate professor. Full stop. The university is recognized by the University Grants Commission and is included in the list of universities which have been given the authority to confer degrees under Section 22 of the UGC Act of 1956. The learned counsel for the petitioner had argued that the nature of the functions being performed by the university are public functions in the field of higher education. And such activities are regulated, supervised, and funded through statutory mechanism. Full stop. It is the submission of the learned counsel for the petitioner that in view of the above, the respondent university would be a state within the meaning of Article 12 of the Constitution of India, and therefore would be amenable to the writ jurisdiction of this court. Elaborating her submissions, since it was the stand of the respondent university that the writ in the present form is not maintainable, the learned counsel for the petitioner has খোলকচোন ওপৰটো খোলক আৰু এই দুইটা খুলি দিয়ক, এইখনো খোলক। আকৌ বাইং থব কিন্তু হা এইখন দিয়ক থাকিবলৈ নাযাব থাকিব কি ক'লো মই লাষ্টৰ চেণ্টেন্সটো has submitted that there can be no doubt that the respondent university delivers a public function by imparting education, and it is a settled position in law that institutions delivering public function like those of education are amenable to the writ jurisdiction under Article 226 of the Constitution of India. The learned counsel for the petitioner has referred to several judgments of the apex court, namely এইকেইটা দি দিব হা এই judgment compilation 1 1 2 3 4 5 হা এইফালে এইকেইটাও দি দিব compilation 2 গিটাও হা The learned counsel for the petitioner has submitted that it will not lie in the mouth of the respondents to characterize themselves as a purely private body while simultaneously enjoying the UGC regulation, statutory degree granting powers and regulatory oversight. Full stop. It is a further argument that since the respondent university is admittedly recognized by the University Grants Commission and is included in the official list of the universities maintained and published by the UGC on its website, the said recognition cannot be said to be symbolic or incidental, but has to be necessarily accompanied by a continuous statutory oversight, expert committee inspection, mandatory compliance to the UGC regulations governing appointments, service condition, research supervision, PhD process, and academic standards. And therefore, it has to necessarily follow that there is a pervasive control of statutory authorities on the respondent university, and therefore the respondent university would be amenable to the writ jurisdiction of this court. By referring to the case of Roychan Abraham versus State of Uttar Pradesh and others, এইখনো is a written argument বুলি যিখন আছে written argument তাৰে page 6 আছে হা page 6 serial number 6 The learned counsel has submitted that the test of direct nexus between the act complained of and the discharge of a public duty was the cornerstone for invoking the extraordinary writ jurisdiction under Article 226 of the Constitution of India. The learned counsel submits that since the university was imparting education, comma, which was a primary state function, comma, a private university like the respondent would also be a necessary ancillary limb in execution of the state function while discharging a public duty. Full stop. The learned counsel for the petitioner has submitted that the termination of the petitioner, who was a PhD supervisor, directly interfered with the statutory research supervision, comma, academic continuity, and the students' compliance with the UGC regulations, comma, thereby establishing a clear public law element in the function being discharged by the university, and the act of the university in terminating the petitioner in the manner in which it has been done would be required to be reviewed by this court while exercising its extraordinary writ jurisdiction. Stop. By referring to the judgment of the apex court in Andi Mukta Sadguru versus Via Rudani, etu apni pabo page 7 of my online quotation, reported in so and so, the learned counsel for the petition has submitted that appropriate writs may issue against any person and authority performing public duty or public function, irrespective of state ownership or funding. Full stop. She therefore submits that the stand of the respondent authorities in their affidavit in opposition, to the extent that in the absence of any state funding or ownership, comma, the respondent university would not be amenable to the writ jurisdiction is wholly misconceived. The learned counsel for the petitioner has thereafter referred to the case of Dr. Janet Joypal versus SRM University, where, comma, she has asserted that the apex court has held that an institution recognized under the UGC framework and discharging public function of imparting higher education would be amenable to writ jurisdiction. By referring to the judgment of the Supreme Court in K. Krishnamacharyulu versus Sri Venkateshwara Hindu College of Engineering, page 8 or huh? The learned reported in so and so. The learned counsel has submitted that it is settled law that where an institution imparts education, which is a constitutional and a public function, comma, teachers acquire an element of public interest in the performance of their duties, and therefore a writ would be maintainable even against private unaided institutions. Stop. By emphasizing on the violation of the binding UGC norms, by emphasizing on the allegations of violation of binding UGC norms, comma, The learned counsel for the petitioner has submitted that her guideship, which was governed primarily by the UGC regulations, could not have been terminated in the manner it has been done. Full stop. She has argued that when the norms of the UGC have been violated, not only while terminating the services of the petitioner, but resultantly terminating her guideship to at least the two scholars, comma, the actions of the respondents would have to be evaluated by this court in exercise of its powers under Article 226 of the Constitution of India. It is the submission of the learned counsel for the petitioner that the abrupt and arbitrary termination of the petitioner has disrupted ongoing research, undermined the functioning of the SRC and the DRC, and placed irreparable harm on the academic continuity, rendering the action disproportionate, unfair, and contrary to all statutory and institutional framework. The learned counsel for the petitioner has further argued that the very act of issuing a post facto termination order would demonstrate that the respondents have acted in malafide, that their actions are ultra-virus and unlawful, and in violation of the UGC PhD norms. The learned counsel for the petitioner has submitted that the present case does not raise a grievance of is not one relating to enforcing of a private contract simpliciter, but the present petition challenges the disciplinary action taken in breach of UGC mandate procedures, the blatant disregard of prescribed standards of proof, and the denial of safeguards that operate in the public interest to preserve academic freedom and institutional accountability. By referring to the judgment of the apex court rendered in the case of St. Mary's Education Society versus Rajendra Prasad Bhargava, reported in at page 14, reported in so and so, comma, the petitioner has submitted that the grievance raised by the petitioner, that is, the action complained of regarding her termination from service, has a public law element attached to it. It's a The Learned Counsel has submitted that the present dispute is not a generic service dispute against a private employer. Rather, it concerns the respondent university's responsibility to comply with the binding UGC standards and mandatory regulatory architecture governing PhD supervision, academic governance, and grievance and disciplinary safeguards. The Learned Counsel for the petition has submitted that the public law element which is available in this grievance is the breach of binding UGC norms and the university's statutory and regulatory obligations in the governance of higher education and research supervision, and is not confined to a private contract of employment. Full stop. Yes, madam. Anything else to be recorded?
No, Lordship, I think everything has been covered.
We'll have to sit back at 2. Controverting the submissions made by the Learned Counsel for the petitioner, Ms. Chaudhary, Learned Counsel appearing for the university, has submitted that it may be true that the university had been brought into existence by a statute. However, the core issue to be addressed by this court is whether the act complained of by the petitioner would fall under the realm of a discharge of a public function by the university concerned. Full stop. The Learned Counsel for the respondent has submitted that it is settled law, as reflected in the judgment of P.K. Biswas versus Indian Institute of Chemical Biology, reported in page 73, and other similar judgments, that the determinative test for bringing an entity within the ambit of Article 12 is the existence of deep and pervasive state control, particularly in the matters of funding, administration, and functional autonomy. According to the Learned Counsel for the respondent, mere regulatory control, statutory recognition, or incorporation by statute would not be sufficient to clothe a body with the character of a state as enunciated in Article 12 of the Constitution of India. It has been submitted that absence of governmental funding or functional dominance in the university would place the respondent university beyond the definition of state as enunciated in Article 12 of the Constitution of India, and therefore the university would not be amenable to the writ jurisdiction of this court. She has also referred to the absence of deep and pervasive government control across the domains of finance, function and administration of the university. Full stop. The learned counsel for the respondents have further submitted that the university is governed by its first statutes framed under Section 6, read with Section 30 of the Assam Private Universities Act 2007. And therefore, the university functions within its statutory framework, independent of state control, full stop. The service condition of its employees are regulated exclusively by the Act of 2013 without any interference of any of the entities which can be said to be within the purview of the definition of state. Full stop. She has submitted that mere legislative incorporation does not equal to ownership by the state, but is only a statutory prerequisite for the establishment of the university. Full stop. It has been submitted on behalf of the respondents that the sponsoring body of the university is a society duly registered under the Societies Registration Act, and therefore the university bears a completely private character. Full stop. The university is wholly financed as required under the relevant act. Full stop. Addressing the argument of the petitioner that the termination of her service involved a public law element, the learned counsel for the respondent has placed reliance on the judgment of the apex court in St. Mary's Education Society and another, within brackets Supra, which had also been relied upon by the learned counsel for the petitioner. Full stop. By referring to the observations made at paragraph 54 of the judgment in St. Mary's, within bracket Supra, the learned counsel has submitted that it has been specifically held that in the cases of retirement and cases of termination, no public law element is involved. The learned counsel for the respondents have further submitted that mere recognition by the UGC does not in any manner render the respondent university to be a state or other authority within the meaning of Article 12 of the Constitution of India. And such recognition is only for the purposes of recognizing the degrees which are conferred by the recognized universities within the territory of India. The learned counsel for the respondent has further submitted that the relationship between the petitioner and the respondent university was purely contractual in nature, governed exclusively by the terms and conditions of appointment, which were elucidated in the contract of employment and which were also governed by the applicable internal statutes and regulations of the university. Full stop. The learned counsel for the respondent has referred to the judgments rendered by the apex court in Ramakrishna Mission and another versus Kago Kunya, page 82 Paboha, and VST Industries Limited, to assert that the aforesaid judgments have affirmed the principle that contract of purely private nature would not be subject to writ jurisdiction merely by reason of the fact that they were structured by statutory provisions. The learned counsel for the respondent has accordingly prayed for dismissal of the writ petition. This court has heard the learned counsels appearing for the parties and has also gone through the different judgments relied upon by the parties. This court notices that in several cases, the issue as to whether a particular entity could be termed as a state within the definition given in Article 12 of the Constitution of India, and further, whether any action by an admitted private entity would have an element of public law involved has been discussed. Without embarking on a this court finds that the apex court in this regard had answered a specific question as to whether a service dispute in the private realm involving a private educational institution and its employee can be adjudicated in a writ petition filed under Article 226 of the Constitution of India in the case of St. Mary's Education Society and another versus Rajendra Prasad Bhargava and others within bracket Supra. The facts as reflected in that case was that an institution, no, a private unaided educational institution, as appellant had approached the apex court being aggrieved by an order passed by the division bench of the High Court wherein it was held that the challenge to the order of termination of the respondent in the appeal before the Supreme Court was maintainable under Article 226 of the Constitution. The respondent before the apex court had challenged the order of termination on various grounds before the single bench of the High Court. And the learned single judge had upheld the preliminary objection raised by the society, private unaided society, and rejected the writ application as not being maintainable. The learned single judge in that case had referred to the judgment of the apex court in K. Krishnamacharyalu comma Frank Anthony Public School Employees Association at end at a and so and so. Full stop. The respondent in the appeal before the Supreme Court was a member of the non-teaching staff of the private unaided institution. Full stop. The apex court, while deciding the issue, had noticed the total absence of governmental control over the functioning and administration of the school, and had also noted that the school was affiliated to the CBSE and was thus governed by its rules and bylaws. Having further noticed that the appellant society and the school were absolutely private institutions without any aid or control of the government or any instrumentality of the government, comma, it was held that the institution was not a state within the meaning of Article 12 of the Constitution. While deciding the lis alias, lis, comma, the apex court had held that while the unaided private institution may be held to be performing a public duty, yet all its decisions would not be subject to judicial review. It was only those decisions which had public element therein that could be reviewed judicially under the writ jurisdiction. It was held that if the action challenged does not have public element, comma, a writ of mandamus cannot be issued as the action could be said to be essentially of a private character. Referring to the contention canvassed by the employee, by the terminated employee, that the writ petition was maintainable if the committee of management controlling the affairs of the institution violated any rule, bylaw laid down by the CBSE, comma, the apex court had held that the mere fact that the board grants recognition to the institution on certain terms and conditions itself would not confer any enforceable right on any person as against the committee of management. The apex court held to the extent that where a teacher or non-teaching staff challenges the action of a committee of management on the ground that it has violated the terms of contract or the rules of the affiliation bylaws, etc., the appropriate remedy would be to approach the CBSE or to take such other legal remedy available under the law. Stop. The apex court had noted that the institution, appellant institution, discharged a public duty to the extent of imparting education, which was a fundamental right of the citizen. Full stop. A very thin line of difference can be drawn here to the extent that while in the case of St. Mary's, comma, the matter related to a school which was imparting education as a matter of fundamental right, which education at the school level, comma, which has been held to be a fundamental right under the Right to Education Act, comma, imparting of higher education has not yet been defined as a fundamental right for the citizens of India. By referring to the case of Apollo Tires Limited versus CP Sebastian, reported in 2009-14 SCC 368, page 163. The apex court observed that confirmation, suspension, transfer, termination, etc. of an employee was a contract of personal service. The apex court had also discussed the judgments rendered in the case of KK Saxena versus International Commission on Irrigation and Drainage and others, reported in 2015 for SCC 670, comma, Andi Mukta Sadguru, Shri Muktaji, so and so. It was a page 165 or 36, comma, G. Bassi Reddy, Pragya Tools, and Federal Bank Limited. Full stop. Reference was also drawn to the case of Janet Joypal versus SRM University and others, reported in 2015, 13 scale 622, to notice that when a private body exercised public function, comma, even if it is not a state, comma, the aggrieved person has a remedy not only under the ordinary law, but also by way of a writ petition under Article 226 of the Constitution. It was held that a private authority may be discharging a public function and that the decision sought to be correct or enforced must be in the discharge of a public function. Full stop. At paragraph 42 of the judgment, comma, the apex court held, paragraph 41, comma 42, comma and 42, comma. The apex court held as follows, 41 or 42 to quote koribo. Okay. The apex court had then referred to the decision in the case of Vidyaram Mishra versus the managing committee, Sri Jainarayan College, 1972, 1 SCC 623, page 172, Pabo, para 40. Wherein it was held as follows. Page 174, more pencil dag diya kini, The apex court had thereafter held that in the absence of statutory provision governing the services of the employees of the private unaided institution, comma, the service of the respondent number 1 in that case was purely contractual. It held that a contract of personal service cannot be enforced specifically. The respondent number 1 therein therefore was held to be disentitled to find a cause of action on any breach of the law, but only on the breach of the contract. It was held that the appellant's remedy, that the respondent's remedy in that case would lie elsewhere, and in no case the writ would be maintainable. by referring to the case of Marwari Balika Vidyalaya, the apex court held that in the said case, the removal of the teacher from service was subject to the approval of the state government, and therefore, in that case, the writ petition was held to be maintainable. It was also noticed that the school in the case of Marwari Balika Vidyalaya was receiving grant in aid to the extent of the dearness allowance, and that all appointments and removal were required to be approved by the district inspector of school, and if any action was taken divorce such mandatory provisions, the same would not come within the realm of private element. The apex court had also held that merely because the state government had regulatory powers, the same by itself would not confer the status of a state upon the school, nor put any such obligations upon it, which may be enforced through a writ, through issue of a writ under Article 226 of the Constitution. The final conclusions were summed up at paragraph 68 of the judgment, which is quoted herein below for a easy reference. Next paragraph. To evaluate the stand of the petitioner, this court finds it necessary to refer to the prayers made in the writ petition, which are as follows. Page 39 of page 40 lage. The first prayer is for quashing of the termination order. The second is for compensation. The third prayer is for restraining the university from utilizing, submitting, or appropriating any part of the petitioner's academic work, research material, or jointly owned thesis through any other supervisor, and to protect the petitioner's intellectual property rights. The fourth being a direction to the respondents to bear the cost of the litigation. And the fifth being a general prayer to pass such orders as may be deemed fit in the interest of justice. This court does not find that the prayers made have any element of line to continue. The prayers made, if granted, would be relief private to the petitioner. To evaluate the cause of action of the petitioner vis-a-vis the submission, that it carries an element of public function, the writ petition, the assertions made in the writ petition have to be perused. From a perusal, this court finds that the petitioner has emphasized on the discharge of education by the university to be a public function, but there is no reference that the service condition of the petitioner, governed by the rules of the university, had any element of public function attached to it. Since this court has extensively dealt with the observations of the apex court in the case of St. Mary's, it is found relevant to refer to a few of the judgments of this court where the judgment of St. Mary's had been discussed and understood. In the case of Mridula Kumar Hazarika versus the Director of Secondary Education, Assam, reported in 2024 2 GLT 567. This court held as follows. Para 19 or 21. No, para 19 or 20. 26 লগে দিবি হ'ব। In another case titled Manavendra Kumar Sharma versus BCCI, reported in 2024 4 GLT 38, this court, while understanding the import of the judgment rendered in St. Mary's, had held as follows. এই GLT সেইটো বেলেগ হ'ব পাৰে হা, মইতো সুপ্ৰিম কোৰ্টত চাই আছো GLT বেলেগ হ'ব পাৰে হা, দেখুৱাই ল'ব। 29 লৈকে। In New Age Petcoke Private Limited versus the Numoligo Refinery Limited, reported in 2024 5 GLT 69. This court has held as under. Thirty-one. এৰা 31 পৰা আৰম্ভ কৰিব। এৰা 39। তাৰপিছত নেক্সট কৰিব Para 20, no, para 22. Tuta. তাৰপিছত Para 29, 30. In this case, on the facts and circumstances of the case, this court had held the writ petition to be maintainable. Next paragraph. What flows from the aforesaid judgments is that whether a particular function carried out by a private body could be termed to be a public discharge of a public function depends on the facts and circumstances of each case. In the present case, we find that this court finds that the petitioner had been appointed in a private university under certain terms and conditions enunciated in the order of appointment itself, and her tenure of guideship was also limited to the period till which she remained associated as regular faculty of the university. The termination of the petitioner being a private affair between the university and the petitioner, this court is of the opinion that the same would not fall within the realm of discharge of a public function by the university, so as to require this court to interfere or even to evaluate such action in exercise of powers under Article 226 of the Constitution of India. Stuff. It is made clear that the dismissal of the present writ petition on the ground of maintainability will not in any manner prejudice the petitioner to avail such other appropriate remedy as may be available and permissible in law. The instant writ petition, comma, being held to be not maintainable in law, comma, is accordingly dismissed, no cost. We may add a few sentences here and there to correct up the structure, but basically this is the order.
Lordship, just two small correction,
Ah.
if I may just point out. Number one, I had relied on one more judgment during the course of my arguments. It is not a part of my this thing. That citation, I will just hand over to your lordships. They have also relied upon it, Army Welfare Society
Ah.
versus Sunil Kumar Sharma, your lordships. That is the citation 2024, 16 SCC.
Then we may have to
Page
add one
57.
paragraph to the judgment where we will discuss that judgment also.
Paragraph 57. I'll just write that thing and I'll give it to the this thing. Secondly, your lordships have quoted certain paragraphs in your lordships observations of the St. Mary's case. Lordships, that has been supplied by my learned friend as a compilation from verdictum. Those paragraphs do not match the paragraphs of the SCC and line citation.
The paragraph number.
Yes.
The paragraph number.
Specifically, paragraph
So,
68
even
is not paragraph 68.
even those judgments of the Gauhati High Court which we have supplied, I am reading from Supreme today, and I have given the citation of GLT.
So,
So even they will not match. We'll correct it up.
So that
Whatever
is
is there.
75. What your lordships wanted to rely upon.
75. We noticed it. 75 A, B, C, D.
These 1, 2, 3, 4, it's been held.
We noticed it. We'll correct
Just
it up.
wanted to price it.
We'll correct it up. And the other judgment that Army Welfare Society.
Versus
Army Welfare Society, that also had a reference to that.
Society, New Delhi
Ha.
versus Sunil Kumar Sharma and others, 2024. 6. It is also a part of compilation 1, your lordships. What my learned friend had submitted.
Okay.
It is also a part of compilation 1 and paragraph. She has relied on several different paragraphs. I have relied on paragraph 57, your lordships, of that judgment.
Just a minute, let me see.
Again, let me just check the paragraphs of whether
There is perhaps one more.
I had several your lordships.
No, there was one Ravi Kokhar and others. I did not have the time to go through it,
Lordships.
but apparently that is also. It was relating to.
It is my mistake that I think I've perhaps given a written submission as well to your lordships.
It's okay. Here also the question was one of whether it would fall under the state, some Air Force Employees Society. Whether it would fall under Article 226 or not. If there is some mistake in discharge of public function, like imparting education itself, we may interfere, but the act complained of is what we have tried to see. Anyway, you should have it by in a day or two. After we make the corrections, he has to take down all the.
Correct. I'm just giving the relevant paragraphs of the SCC citation, the Army Welfare Society. I'm deeply obliged to your lordships.
27 for hearing
Would be useful.
Yes, sir. Page? हाँ ये बुढ़वा just a minute we are yet to reach the page. Page 11 is what?
Page 11 is lawsuit, the honorable court, page 18 may kindly be looked into lawsuit.
Page?
Page 18, order column. Lawsuit.
हाँ
The respondent, page 19 may kindly be looked
Hey.
into. I am the appellant here.
हाँ
I am the petitioner here, Zakibur Rahman. He is directed to pay maintenance amount of rupees 1,000 per month to the petitioner agreement and has filed under section 20 of that. The respondent is also directed to pay an amount of which 2,000 to the agreed party under section 22 of that. So in lawsuit, all together lawsuit 2,000 was directed to the same user. 3,000 user. So being agreed to it, is not attached to lawsuit order 21 to 2019
No.
lawsuit.
3,000 2,000 is compensation one time and 1,000 per month. Yes. Huh?
They have balanced it, lawsuit. In the form of a steel lawsuit. That is
The court fee must have been more than the court fee and typing fees must have been more than that. Yes.
absolutely, Milan. Now page 20 may kindly look into.
Page 20.
Page 20.
Okay.
By judgment of order dated 17/3/2012 lawsuit.
Ah.
It has been enhanced to lawsuit.
To how much?
So 3,000 to you lawsuit, altogether 3,000 to 3,500. And also a quantum of rupees you lawsuit 40,000. That is.
Have you paid the 3,000 and 3,500?
3,500 and 40,000 you lost. 40,000 is a compensation you lost.
Where do we find it? It has been made 3,500.
Page 26 the time you looked into loss.
Page 25
25 to 26.
would be just an adequate proper amount of maintenance for the appellant and her minor son. This was given in when? 2022. You have not applied for enhancement.
My lord, I have.
You have?
IA has been filed.
In the High Court.
Okay. And 40,000 as compensation.
My lord,
Okay.
That too is not provided to us, my lord.
So now.
1,000, my lord, 1,000 and 2,000. 1,000, my lord, that was passed by the learned trial judge. Appellate judge, my lord, say enhanced it to 3,500. Now, my lord, that amount, against that they have preferred this revision, my lord. This honorable court, as per order dated, my lord, state the, my lord, impugn order. That is the appellate court's order, my lord.
No, just tell us one thing.
Yes.
You are required to pay 1,000 per month. Have you?
As per the information we are seeing.
No, my lord.
As per.
It has not been paid.
It is not paid. It has
Bring
not
us
been-
proof day after tomorrow.
My lord.
Bring us proof that this 1,000 has been paid from 2022 till date. Unless it is paid, we shall have.
Commission here. So other day also informed that 1,000.
Day after tomorrow, show us the bank statement that it has been paid.
Correct.
Lost is,
It has been paid in cash.
thing they deposited in the trial court below.
Get us
So
that.
therefore, in lordship, the 2 days may not be.
24th.
sufficient.
We'll have it on the 24th.
After 24th, because it may not be possible in lordship, because sometimes it may happen.
Why, my
that
lord,
some
it
certificate
say-
will need to be obtained in lordship.
On-
Go and obtain it.
So therefore, in lordship, it may be.
Nagaon.
After 30, you lordship.
Nagaon is a very quick court, we are
Yes,
told.
my lord.
Nagaon is a very up and doing court. You apply certificate copy at 11, you get it at 1.
Passions, you lorships, may it be on 30, you lordship.
No, my lord. My lordship kindly similar since
26.
2022, my lord.
Either it is,
2022, my lord, I am suffering.
the learned counsel appearing for the respondent has submitted
I have got
that
one child.
the-
My lord, school.
that the maintenance directed to be paid by the petitioner to the respondent number 2 by the order that 552022 has not been paid till date. Full stop. Learned counsel for the petitioner has sought for an accommodation to bring on record adequate proof that the maintenance has been paid.
1,000.
Eh?
That 1,000.
Whatever,
Yes, sir. But he's denying, but my information does not pay.
1,000.
522 has been
Lord,
paid. List again on 26th of March.
1,000 for me as well as
We
my
do not know
son.
that. We asked you whether 1,000 has been paid to you as per the order or not. You said no.
My instruction is no.
Then good enough. He's going to
No,
bring proof.
My lord, your lordship kindly appreciate, my lord. 1,000 for me as well as my son, who is a school going
See,
child.
if he has paid the 1,000 to you,
My lord.
we will decide the case on merits on 26th.
Order is-
If he has not paid that 1,000 to you because of non-compliance of the orders of this court, we will dismiss the petition. It is a matter of
Yes, sir.
9 more days.
So that has to be ascertained.
I'll bear, my lord, yes.
9 more days. Yes, next.
I'm obliged.
আর কেটা আছে আৰু ছটা কেতিয়া ছটা বুলি ক'লো yes
14 the info order passed by the learned citizen.
huh
6:30 the info order. Accused Raja Prasad is present. Third, both the learned PC and the learned advocate declare the accused person on consideration charge. Also, peruse the case report thoroughly. In this case, the accused has been charged with committing an offense punishable under section 406 slash 30776, I believe. After consideration of the record of the case and the documents submitted therewith, after hearing the submission of the learned counsel for the accused and the prosecution, I have the opinion that there is a ground for presuming that the accused has committed an offense under the section 370. The court has framed the charge under section 370. Now, if you go through the record, there is no offense under section 370. Then this case has been arising out of a FIR log by the respondent number 2. Kindly turn up at page 14, the FIR. Page 14, and it's one spot.
page 14 yes
Thereafter, it was transferred to the Dismissal police station for jurisdiction purpose. I'll just read out the affair. With all due respect, I beg to state that I alone with Sri Radha people, resident of Uluvali, in the since 2017, and we both were sharing a rented room at survey house number 27, Denver. In the month of March 2020, owing to the corona, he has taken away all the status his residence at Uluvali, and I tried to go to my own residence. However, my family members did not support me and let me decide as Bandar. Again, in the month of September, I came to Gauhati, and therefore both of us started to reside in a rented house as Meghalaya. Actually, I conceived for a period of 2 months. I became pregnant for 2-3 months. Earlier, but Raja Prasad, after coming to know about my pregnancy, denied the paternity of the fetus and asked for DNA test resulting the paternity become. So, in the FIR, so kindly see that there after registering the FIR, the case was charged sheet, and during the investigation, the court it was charged sheet under section 406 and 376. Can you see that 161 statement?
yes sir have you gone through it
Yes, my lord, I have.
where is 376
The question is that, my lord,
Huh?
though there is direct 376 is not there, my lord, what I am submitting, my lord. They were living, there are some love affairs, my lord, so they were living together, my lord. And kindly see them, my lord, FIR, man, contents of the FIR, my lord.
twice abortion
Before that, my lord, 2-3 times she was pregnant before that, my lord. And there was, my lord, also.
and how 2-3 times because she went back to him again and again
Yes, again and again.
then
He was repeated even in her one.
Oh, madam, the conduct of your client is not very praiseworthy.
The question is that, my lord, if somebody assured me, my lord, that I'll marry you, my lord, because she live together with him, my lord, with the assurance that, my lord, the person will, my accused will marry her, my lord. After that, my lord, if the accused person, my lord, refused to marry her, even, my lord, he said, questions her, my lord, pregnancy, my lord. That
Is it rape?
that may not become, my lord, but let the trial go, my lord.
Why?
Why, my lord? What is
When
the
the
wrong?
charge is wrong, why?
Why where there is, my lord?
Go for cheating, go for whatever you want. How can there be a trial for rape?
The question is, my lord, the case has been charged.
Every failed love
406
relation
is
will
also there.
otherwise, every failed love relation will otherwise come into the offense of rape.
She has given consent. Because the petitioner never denies that he will not marry her. He will marry, but he has not broken down his promise. But it was.
He already has another wife.
The,
Appears that he has another wife, is it
In
not?
this case, my lord, the appearance of the, my lord, opposite party number 2 is, my lord, that is necessary, my lord.
Huh?
but
My lord, the appearance of the opposite party number 2 is necessary, my lord. Whether, my lord, the notice has been served or not, I could not find, my lord. So let some amicus may be appointed.
If they are not appearing, what to do?
Let some amicus be appointed.
In 376 cases, we have to appoint amicus. Is there a necessity?
This is the final hearing, my lord.
so already paper publication I have done the.
Okay.
We have done the paper publication.
He wants a amicus to be appointed to defend it.
So that, my lord,
Done.
victim can be represented, my
Huh?
lord. My submission to
understand.
appoint amicus curiae so that the victim can be represented, my lord.
Yes.
Even if she did not effect the time of the several times she was called. She did not. She is not because if she could have intention to represent because she herself consented with them to have relationship with.
And secondly, my lord, this is the order of, my lord, 2020.
What do you say? Her disappearance may not be the on the grounds that you have stated. There may be other reasons.
Is there any stay order?
But then we are just to see whether yes, from where this 376 is coming up.
My lord, one more submission, my lord. This is an order of 2018, 12, 2021, my lord.
Eh?
Now, my lord, it is more than, my lord, 5 years.
5 years.
So whether, my lord, there is no stay order probably, my lord. So, my lord, if the trial has
No,
proceeded,
no,
my
no.
lord.
Liberty was granted to them to pray for adjournment.
What is there? But the scan copy does not reflect anything. my lord.
Eh?
The scan copy of the record, my lord, it does not reflect anything, my lord, regarding the, my lord, trial.
Ms. So-and-so appears for the petitioner. Mr. Borua for learned APP appears for the state. It is seen that even after paper publication, the respondent number 2 has not entered appearance, full stop, to protect the interests of a victim, of an alleged victim of 37, of alleged victim, comma. This court deems it fit to appoint a amicus. Amicus is induction. Suggest. By stay school. Srimati Nazia Hassan as the amicus curiae in the matter. No. You do it this way. Nazia Hassan as the amicus in the matter. The petitioner shall cause service of a copy of the appeal upon the amicus. Release the matter again on 31st of March. When? When do you want it? On the 7th of March? 7th of March?
7th of April.
April. 7th of April.
May I pray, my lord, the up-to-date status report may be called for of the trial court. What is the, we can go through, my lord, what is
The counsel for the petitioner shall also submit the up-to-date status of the trial.
my lord?
You bring your up-to-date status of the trial, what stage it is in. Yes, sir.
Legal aid counsel.
What was those, what were those judgments?
First,
On what issue?
contradiction, how contradiction is to be proved. Because I was not examining this case.
IO was not examined.
There are material contradiction. There is four witnesses were examined. PW1 is the prosecutor, this victim. PW2 is the doctor. They told her mother and father. And FIR was also lodged after 5 months. So, AO was not examined. There is a delay in lodging FIR. So, if as IO was not examined, we could not prove the contradictions, the material contradictions, which is apparent from the position of PW1.
Why was it taken under 376?
She is above around 19 years at that time.
Huh?
She is 19 years at that time.
No, তিনচুকীয়া মিছনৰ পৰা মোৰ ভিনিদেউ উত্তম ঘৰত মোৰ ছোৱালী কুমাৰী ইমান ফুৰিবলৈ যাওঁতে তাত তেওঁ উত্তম দাসে তাইক ফুচুলাই তাইৰ লগত সহবাস কৰে ফলত বৰ্তমান মই উপস্থিত হয় ফুচুলালে even ফুচুলা now becomes rape.
That is the FIR. But as per the statement of the victim, as per the statement of the
Who is a
victim,
major?
major,
Who was a major? Who did not lodge the FIR?
he did not lodge the FIR. The accused is Mosa.
She told her mother
Mother-
that anybody in the
Some contradiction, minor contradiction is yes,
Is there?
is there. She in her cross. If I have trademarked the PW1 in the record.
I have also annexed option.
There.
Record to divorce. Dada.
PW1, just tell us, we have PW1.
Page 23.
Tell us, what is the contradiction?
Regarding that, after 5 months when detected by mother, menstruation stopped, then went to doctor, then only FIR. That is there. And she said that around December, but medical officer in her said that if pregnancy in December, her one menstruation in January, that may not be. That little contradiction is there. And regarding non-reporting to the mother, out of fear, out of shame and all this, that person, the accused person has a girl of around 26 years, older than this victim around 19 at this stage. So, that girl, because of divorce, she is in her father's house. Even then, that relation, first incident, it was forceful.
See, the report of May 2019 says
Pregnancy.
21 weeks.
Yes.
21 weeks would be 5 months.
5 months.
In May, January. Okay.
Yeah.
Okay.
And incident, she left, she stayed there around 20 days. She left that house on 17/1/2019. First incident of December 2018. Subsequent to that was first night is forceful. Subsequent to that, she stated that she gave me some chocolate or something.
Subsequently, I became unconscious, and in the morning, I felt that something has happened. The, that is there, and that incident was going on a few occasions. How many times it is not mentioned? Few occasions. But she didn't disclose. That is there.
Every time she is offered a chocolate, she becomes unconscious and
Yes, two, 3 occasions like that.
She is a very chocolatey person.
But regarding she didn't disclose to her aunt, she didn't disclose to the brother, sister, cousin sister. She didn't disclose to the brother. Brother went her to take to home, and even mother lost the father lost the affair. When she lost her menstruation, and then only
Then she came to.
so, if Malat goes by the Malat cross part, house is also Malat that is three rooms house. Doors are not open door. Some doubt is there, but maybe due to same, maybe due to Malat fear, Malat Mosa related.
Something happened, but whether it was 376, that is the issue. Whether 376 has been proved.
But as per the statement, as per her statement, first incident was forceful. Let me kindly go through her statement.
There is no proof of that first incident.
Prosecuting herself, in rape, 376.
Then her repeated visit to that house.
No, not repeated. She stayed. She stayed.
Hmm.
Subsequently, her brother came along with her brother. She went. Subsequently, about 17, 18 days, around 20 days, 15, 20 days, she stayed. That in the cross somewhere it is mentioned that she went on 17/1/2019.
There are material contradictions also. Unexplained delay in lodging the FIR. It has not been explained in
But
our
one thing is that I have noticed, Malat,
deposition also.
though in this said, Malat, I have to mention, Malat, see, regarding delay in FIR, it is not mentioned. Why is she not disclosed before murder? For what it is not disclosed to the mother, that is also not there. That Malat.
I have a recent decision lawsuit, similar type of case, where prosecutor, sole prosecutrix, she did not tell anyone. And there was a delay of 7 months in the FIR, in lodging the FIR.
Now, in this judgment, which instance has been taken to be?
Only chief lawsuit. Chief has been considered. Contradiction was not considered. Page 49, paragraph 19. Apparently, there is no eyewitness in this case, since the evidence of the victim is most vital in this case. The fact of the victim's statements has been considered.
That accused remains alone in the house.
No.
He has a full family with him.
His wife, his
the
minor son.
minor son.
And she first in a deposition, she stated that on the first night she was given to sleep with a minor son of the accused.
Subsequently, he awake and that father came.
Story is a doubtful story. Interesting.
Yes, which judgment do you have? এটা কোন চলাই দিয়কচোন এই সিটো Please hold on. Suffocating miss. He is behind bars? He is behind bars
Yes, sir.
as of now?
Or,
I was rejected. I rejected.
may take up Rajendra, which is
Hmm.
dated 13th
Hmm.
2016. Paragraph. Same story.
But there the enmity and inconsistency. Enmity, what kind of enmity? In that case, there was a ground of enmity.
Like not there.
Eh?
Here, enmity like things are not there.
There are also sole prosecution, evidence of sole prosecution. Political evidence. Only analysis of 1314.
Yes, madam. What do you say?
Passed out because my lord, this persons. It's a very serious matter, my lord. Prosecution has established the case beyond all reasonable doubt, my lord.
What do you say under delay?
There are sufficient. Regarding delay, my lord,
Hmm?
he was threatening her not to speak any others, my lord.
That has not come up anywhere. She was there for 20 days. She came back to her home. How he can go and threaten?
In this regard, my lord, only one point, my lord, I want to make submit, my lord. Accused person gagged her mouth by his hand and then he raped her. Regarding the point of delay, my lord, yes, my lord, too much delay.
Supreme Court, in the case that he has submitted,
Yes, my lord.
Supreme Court has said that it will be, where is it? It would be hazardous to convict on the sole oral testimony when the prosecutrix has waited for months before filing an FIR.
Yes, my lord, after 5 months.
It has also been held that had it been done at an early point of time, some evidence could have been there.
Yes, my lord.
Waiting till things go out of hand.
When she was pregnant, death, their guardian filed this.
Close it.
Regarding non-examination, I wish to submit question.
I was not okay. Only he is a medical, he other.
In contradiction, Mr. on last occasion, I took time in the regarding contradiction. How contradiction is.
Give all your judgments. Whatever you want to give. Dear kid. Heard Mr. Spencer. Forecastle and a counsel appearing for the appellant also heard APP and
I'm appearing at legal aid counsel under
And-
respondent number 2.
legal aid counsel appearing respondent number 2. Arguments heard, judgment reserved.
Bahadur Nayak is for this non-examination of IO. Paragraph 2, simple. The appellant has not been able to.
Non-examination of IO not fatal to prosecution case. Huh?
Let us take no material contradiction. In this case, we are saying there is a material contradiction.
Okay.
There are material contradictions.
Hmm.
And how contradiction has to be proved in next judgment question. Paragraph 16 to 18. 16 to 18.
16 to 18.
18. That has to be IO confronted with the IO.
Huh.
Otherwise,
Very
there is
good.
no.
CB.
I'm obliged.
Well, what I'm praying is that he's perfectly to be on legs. They're continuing an interim order, and I say on the basis of a Supreme Court order, Miller, that at page 34, the cognizance
On
was
the
taken.
last occasion, we had said that
Same
let
thing
him,
was happening.
let him enjoy for some more time.
This
That is-
cognizance was taken is bad. I appreciate.
Uh.
What is to be done? Because the pre-cognizance hearing was not given. What is to be done? I have a judgment. Copy from Guru, sir. Certainly, but the Supreme Court is very clear on that. The order is set aside and it starts from that point. They'll go in appeal. That's all. Now the interim order continues. Let it continue till 4:30. I'll be back. I'll be here. Not beyond.
Interim order till 4:30 only
4:30 only.
is
I'm
prayer.
here.
Huh? After that, no interim.
Sir.
Yes, madam.
Mr. R.K.T. Chaudhary is on legs in post number 7.
I think.
So if
Hmm?
pending,
You were also challenging some order which was taken, which took cognizance, something like that. The charge. We'll wait for some time. Let Mr. Chaudhary be.
33.
Yes. Yes. On the last occasion also, there was a paucity of time, huh? Yes, tell us.
1599 and 5 report is on the court. Seeking for setting aside the order of the district court, upholding a non-existing and merely and obviously a typographical error in the daughter document, secondary document, that is charged.
Yes, we remember that. Yes. Some section was wrongly quoted. Anna?
Yes. A gift given to me by the steno of the Honorable Trial Court. It was not in the mind of the Honorable Trial Court that 217 was not there.
Where will you lead us again to this particular things? Yes, sir. Tell us. Mr. Parashar.
It seems to be first occasion to typographical error. Otherwise, it is not there. That day also my lord has mentioned, my lord. But subsequently on 217, my lord, that is taken.
Where is that? What is this judgment?
Number 46, sir.
Page number 46.
That is the operating part, the last part, where the Honorable Court gives a vague and a non-cogent order of upholding something and asking the trial court to make it clear, which is hollow in meaning. It's like
No, where is that?
charge form. This page number 85, sir. Any number of times we can read charge form, sir, page number 85. 217 is actually overwhelmingly it is typographical error.
Huh?
The heading of the charge.
Where is that charge?
Charge form, sir.
Huh?
85, sir, page number 85. The heading of the charge form is proclaims loudly, clearly, sir, charged with 2 heads only. heading itself.
What do you say about this part, page 46, the top part? Or page 45, para 17?
Yes. Two one seven.
You are in service now?
Yes, sir. Far out of Barpeta.
Barpeta,
Far out. Foreigners, regional.
foreigners.
So the police took 5 years and 9 months to investigate this case. And finally, they charge sheeted the case before the Honorable Trial Court. And very thankful to the Honorable Trial Court, all the 9 sections that were invoked in the charge sheet were dropped by the Honorable. However, sir, unfortunately, Honorable Trial Court brought in a new section which was not in the charge sheet under its own power and authority. That is section 218 of IPC, read with 98A Assam Police. When that was challenged before the Honorable District Court, sir, the Honorable District Court was pleased to set aside section 218 of IPC. However, picking up this.
What happens to 98A?
98A.
98A?
That is not an independent section, sir. That leans on the support of the primary section 217.
Oh.
18 of it. It's not an independent section. So,
Yes, what do you say?
But
This in that criminal revision, that is something. In criminal revision, page 36, let us assume, for the time being, that the court was dealing it correctly. Now, from when did criminal revisionary powers
direct.
give the power to add a section or to
Yes.
say that this is the section correct, explain it and all that? What is
The only
The
revision.
challenge was whether 218 was correctly applied or not. How did you decide the application of 217?
217.
Had that part not been done, the petitioner would be at liberty to approach the trial court to say that, look, 218 has been set aside. You made a typographical error. Please correct it. Drop the charges. Trial court could have done it. Now the revisionary order has imposed a section upon him which was not the intent of the trial court.
Yes.
Such
Intent
being
of
the
the trial-
position, it will require interference. What do you say? You set it aside.
Malan.
That part, है ना?
Revisional court मतलब directly.
and the contentious documents that is the progress report. That report is actually, it is not part of the charge sheet. Without the document there being the charge sheet, unfortunately, the Honorable Trial Court also invokes section 218 of IPC. What is section 218
No,
of IPC?
the invocation of 218 has been set aside.
Yes, sir.
Yes.
We will not interfere with that part. That part of the revisional order which which upheld 217, we will simply say that that does not appear to be the charge sought to be framed by the trial court.
That has been
Appears to be a typographical error. Revisional court exceeded its jurisdiction in trying to make out a new charge, and therefore we are setting that part of the order aside. That suffices.
Yes.
That is justice. That will be justifiable. Okay.
Revi-
Huh?
Because it is earlier not there, only revisional court has brought it matter.
How can he introduce the charges?
New.
corresponding departmental proceedings also have been closed, sir. I have been exonerated. None of the charges could be by the discipline authority. I have. The next week of my DP being closed, unfortunately, this charge sheet was flat. Because the government norms is once the DP is closed and the honorably the government servant is exonerated, he is entitled for promotion as per the norms, if the case is still under the investigation. So, the next week, the December 27th, the Honorable Disciplinary Authority closed the DP, exonerated me, all the order is there in page number 91, sir. The Governor of Assam. In January, first week, this charge sheet.
After about 6 years,
And-
around 6 years.
Yes, that also, and all the sections in the statute could not be stand the scrutiny of the Honorable Trial Court at the argumental charges. So what the police did, they are doing for 5 years and 9 months, that none of the sections invoked in the charge sheet against me could not stand. Is also an indication that what is the going on.
In here, we have got a saying that there is a itch on the doctor's nose. You are a part and parcel of that course, are you not? So the itch is now on the doctor's nose. That is on a lighter note, huh? Okay. That trial is ongoing.
Now it has been stayed by this
Stayed.
Honorable Court.
It is stayed.
18th of December 2025. This Honorable Court made a very detailed order in that final concluding paragraph. It has stayed the order, sir. That particular order captures the essence of that.
1812. 1812. First order, my lord.
Paragraph 8 of that particular order of this Honorable Court more or less captures the essence of the case.
देखिए. Heard Dr. N. You say Raja Marthandan, is it? You'll find it at this thing, order dated 18/12/2025. The petitioner in person and Mr. K.K. Parasal and at APP. Full stop. While issuing notice on 18/12/2025, this court had recorded as follows. Copy the order dated 18/12/2025 as well. Okay? Stop. We have heard the learned, this court has heard the learned counsel for the learned counsel, learned APP and the petitioner in person. Stop. The observation made in the order dated 18/12/2025 to the extent that the inclusion of no that the that there was no specific charge framed under section 217 of the IPC has been deliberated upon by both the contesting parties, full stop. This court has also gone through the order framing charges dated 21st day of May 2024. This court is of the considered opinion that when there was no discussion with regard to the manner in which a charge could be framed under section 217 of the IPC regarding the petitioner, this court, no, the reference to the direction for the petitioner to be charged or to be tried under charges framed under 217 of the IPC appears to be a typographical error, full stop. This court notices that the sentence by which the petitioner was directed to be tried is reads thus. करके वो ये from page 85 I have given that one sentence, and hereby I direct you to be tried by the said court on the said charge. Said, there is a word said. Bold करके उसको inverted commas कर देना है. ठीक है? This amply displays that the intent of the order dated 21st day of May 2024 was to have the petitioner tried on the charges of committing an offense punishable under section 218 of the IPC and not of committing an offense punishable under section 217 of the IPC. Full stop. The learned revisional court by the order dated 24/3/2025 has already held that that section 218 of the IPC is not attracted in the case of the petitioner. Full stop. This court, on going through the order dated 24/3/2025, passed in criminal revision 53 of 2024 by the court of the learned additional session judge number 1 Kamrup Metro Gauhati, finds that once the learned court had come to a conclusion that the provisions of section 218 of the IPC was not attracted in the case of the petitioner, there was no necessity for the trial court to have examined whether the case of the petitioner would be covered by any other provision of the IPC, more so when no such prayer had been referred to either on behalf of the state or on behalf of the petitioner in the criminal revision proceedings. Full stop. In such view of the matter, and it was in that view of the matter that this court had kept the relevant kept that part of the order of the revisional court in abeyance. Full stop. Having gone through the materials on record, this court deems it appropriate to make absolute the interim protection granted to the extent that the order dated 24/3/2025 passed by the learned additional session judge number 1 Kamrup Metro Gauhati in criminal revision number 53 of 2024 shall stand set aside and quashed on and from paragraph 12 to paragraph 21, paragraph 19 of the said order. Full stop. Accordingly, the proceedings under PR case number 234 of 2023 shall also stand closed, since the revisional court had already held that the provisions of section 218 of the IPC would not be attracted to the instant case, and since the provisions of sections 98 within brackets small a of the Assam Police Act cannot stand alone to have the effect of having the petitioner face a trial. Full stop. The criminal petition is accordingly allowed to the extent indicated above. Trial court records are not here, no?
What is it? I was the one.
Huh?
What is this?
IA for what?
The interlocutory petition for early hearing only, sir, nothing.
No, that may be all dispute.
In view of the orders, in the interlocutory application, you write, in view of the orders passed today, no orders are called for in the interlocutory application since the same was for an early hearing.
It will be closed.
It is accordingly closed.
Item 31.
We'll elaborate the order to some extent, but this is basically what we have put. Few corrections will come in.
31.
Ah,
Well, that would not be in quite favor. I strongly object to that paper.
eh?
No,
Eh?
I'm not on that, only this. I concede it is wrong. I'm not contesting the matter. I concede it is wrong. And this is what the Apex Court has said, Miller. The last paragraph, the second last page. Second last paragraph. Interim order may not continue, that's all.
Eh?
Interim, because they are not attending the matter, they would take cover of the interim protection, and I'm not even contesting the matter. I'm conceding it's wrong. No advantage is being taken. The second last, Miller. The second last page and the second last paragraph.
Non-compliance of the
Yes.
proviso to subsection 1 of section 223 of the BNSS.
No, I'm not on this. I'm on the subsequent paragraphs. We make it clear that we have not expressed an opinion on the merits of the complaint and therefore said contentions raised by the learned additional solicitor general. We direct the appellant to appear before the special court on 14th so that he can be given an opportunity of being heard in terms of the proviso so and so and so. Make it clear that no further notice be issued. Well, I concede he's quite young, a lawyer. Tomorrow at 2. That much. Tomorrow at 2.
Do you have a copy of this judgment?
I'll give it. It's okay. Tomorrow at 2. I have considered on that.
You carry this and you come back tomorrow
At 2 o'clock.
at 2 o'clock.
At 2. Very fixed matter. Of course. Tomorrow till 2.
Till tomorrow.
Of course.
But you said you'll object after 4:30.
It's okay. He's too young. We also had those days with her. Tomorrow at 2 o'clock. Mr.
Huh?
Deori would have been different.
List again tomorrow the request of the learned counsel for the petitioner. Stop. Interim order continues till 2 o'clock tomorrow.
Of like lot. The matter will be fixed as a fixed item at 2 o'clock.
I said interim order will continue till
Right.
2 o'clock.
Wait.
They don't write that 2 o'clock.
Let the matter be fixed at 2 p.m. That indicates.
We'll remember at 2. Once we see you, we'll remember.
Right. Wait.
You are very hard to forget.
That you may pray for a date now.
Huh?
That we still continuing. May pray for a date.
But I think she's facing prosecution. Are you facing prosecution? Huh?
Not proceeding.
Oh, proceeding before the learned trial court shall remain in abeyance.
Yes.
It is in abeyance. You know, part had कोई उठवा नहीं. नहीं जानी. को part had नहीं लोग. You are under a protection. Their objection is on objection to the record. You would like to file a reply to the objection, or we take up the matter? Huh?
Second week of April.
31st is a Tuesday.
Yes, Lordship.
Huh? 31st of March? The objection filed by the learned, by, oh, is on record. ठीक है. So once it is kept in abeyance, why? The interim order passed earlier continues. List again on 31/3/2026.